Good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everybody, so much for being here. I am so sorry that I missed last week. I was feeling more than a little bit under the weather, but I'm feeling much better today. In fact, I'm feeling juiced. Who's feeling juiced? Kaylin is feeling juiced. Tiffany's definitely feeling juiced this morning. We're all in a very, very good mood because Thanksgiving's coming up. It's the beginning of the holiday season. Fun times, fun times. I'm so glad that so many of you could make it here this morning. Thank you to Johnny Knoxville and Crazy Mary Joe and Porter, therapists Shy Gal, Maureen from Monterey, Afton. I see you all in the chat, and I'm so glad that you guys were able to carve out some time on a Sunday morning to join us. To everybody who's returning and knows all about Sunday Fun Day, welcome back. To everybody who's new here, you are in for a treat. But first, let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for about 10 years. I left to go into private practice as a criminal defense attorney, and this is Courtroom Confidential, where we do our best to present to you both sides of the courtroom. And you showed up for a great episode because today is what we call Sunday Fun Day, where we take your questions that you have left us throughout the week in voice messages, and we answer them live. As always, please stay to the end for announcements. We do have some fun announcements because we've got some different programming this week with the holidays and some special treats for you that I think you will enjoy. And I think that's everything I need to tell you ahead of time before we start to jump into these questions. You guys showed up, by the way. We got a lot to get through because we've got 2 weeks worth. Again, sorry for my absence. Katie May, 22, just became a member. Well, welcome aboard, Katie May. I think you enjoyed it. And Johnny Knoxville's probably the one that gifted her that membership. Maybe not. I don't know. But thank you so much. Jadzia Dax, 1969, has been a member for 9 months. CC, baby. Happy Sunday Fun Day, everybody. Yeah, I like it. Jadzia Dax is juiced as well. Take a deep breath. It's Sunday. You've made it through another week. Hit that like button. Go ahead and take a moment. You'll feel better about it. Hit that like button. If you're not already a subscriber, please subscribe now and share this with anybody that you think might enjoy it. But let's jump in to our first question and see who's going to kick us off this morning. You can do this, Ritter. Here we go.
Hey Josh, my name is Taylor and I'm from Springfield, Missouri. I'm really curious to know more about the Craig Daniel Wood case and in regards to the death penalty and how close he is to actually be put to death. I know that he just had a recent hearing where he was trying to fight against his death penalty case, but I'm curious, how many more does he have before he is, and just your thoughts on the case in general. Thank you.
Taylor from Springfield, Missouri. Let's go ahead and put you on the map. Is that our first person out of Springfield? Welcome. No. Okay. Well, still welcome. Thank you so much for calling in. Thank you so much for this question. This is a horrible case. They're all horrible. Anytime somebody gets killed, it's horrible. All the stuff we talk about is not the greatest stuff in the entire world, but it's fascinating. And this one is no less fascinating because it involves the horrific death of a very young girl by the name of Haley Owens. This took place back in February of 2014 in Springfield, Missouri. So that's probably why Taylor has a special interest in it. This man, Craig Michael Wood, is accused of, here's the quick version and circumstances that will give you nightmares about this case. He was apparently like a former middle school football coach, some kind of style loosely connected to the athletics at that middle school. Haley Owens, 14 years old, is walking home. And 14, by the way, I don't think is at that age where any of us are going, what in the world is a girl that young walking around? I think 14, you're starting to think, I don't think that's a picture of her when she is 14 by the way. We were trying to find one that looked more like it was recent in time. But, 14 years old, kind of reasonable for her to be walking home. And a truck, literally this is out of, the parent workbook on nightmares. A truck pulls up next to her, starts to talk to her, and the man in the truck gets out and abducts her, grabs her, throws her into the truck, and takes off speeding. Witnesses, good Samaritans, were in their garage, and they see this happen, and they take off running and smart jot down the license plate. Somebody actually takes off in a car trying to chase after him. I love these, people who are not saying to themselves, not my problem, but are saying, we need to do something about this. That wasn't right. They use the license plate information and they match it to the Wood family, who says that the only person who drives that truck is our son, Craig. They search the home and they find, tragically, Haley already dead, wrapped into some garbage bags inside of storage containers. It looks as though she's been bound. It looks as though she's been assaulted, the R word, and she's been shot in the back of the head. They further search the home after he is arrested and find what I'm going to describe as CP throughout his personal belongings. You can kind of put together what that is. And he's convicted in 2014. Now, what's interesting about this case from a legal perspective is that this takes place in Missouri, and Indiana, I think it is. Let me take a look at, yes, are the only states to allow what I'm about to tell you to happen. At the end of the trial, the jury is unable to reach a unanimous decision on death. In the vast majority of states, I think in the other 48 states or the other states remaining that have the death penalty on the books, if there is no unanimous verdict on death by the jurors, the default is just life without parole. So it's not like you retry things. A mistrial is not declared on the penalty phase. It's just, if you can't agree, you default to life without parole. Not in Missouri or Indiana. In those states, if you cannot unanimously reach a verdict, the judge gets to decide. And in this case, Judge Thomas Mountjoy, having heard the circumstances of this case, unsurprising to me, and I think most folks, says, you know what, you're good for the death penalty, and goes ahead and sentences him to death. So that's what's happening now. He's appealing that. Your question, Taylor, was what happens next? Does he have a chance? How many appeals does he get? The answer is he will get an exhaustive amount of appeals, all the way up to probably a habeas petition right at the very end. It doesn't look like anything was improper in my research about the way that the trial was conducted, which is what they're looking for on appeal. Appeals are about take the four corners of the trial, look at the legal decisions made, not really the factual determinations made, but the legal decisions made, and try to figure out what did the judge do wrong legally? And if there's something the judge did wrong legally, and that's an error that cannot be cured, or an error that they feel was somehow detrimental to his rights, or what we would call a reversible error, then he might get a new trial. Putting that all aside, the appeals should just all be denied. He had oral arguments on November 5th, arguing ineffective assistance of counsel, saying his attorneys didn't make proper objections and his attorney should have made different types of arguments, things like that. I will say IAC is usually kind of a last-ditch effort as well. It's like, I've tried all the legal arguments. Now I'm just going to say my attorneys were awful and see if that gets me a chance. He's just basically trying to get the death penalty off the table. The only thing I will say about this is I wonder how much appellate scrutiny the idea of a judge choosing the death penalty has come under, and how recently that has taken place. If it hadn't been appealed on that particular issue in Indiana for decades, and this is the first case where a judge has done that and it's gone up on appeal, you might see something. You might see the Supreme Court in Indiana saying, or pardon me, Missouri, I said Indiana, in Missouri saying, you know what, this somehow is abusive of his constitutional rights because everybody's got a right to a jury of their peers, blah, 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 blah. But putting that aside, I think he's probably going to be looking at the death penalty someday. So that's just kind of my shooting from the hip assessment of this case. But Taylor, thank you so much for bringing our attention to a very important case taking place in your home state that I was not aware of, at least. And we appreciate you calling in. Mary Jubinville, thank you so much for the super chat, says Florida allows for only 8 out of 12 for death penalty. That is true. That's a very good point. You're right. I said unanimous, but some states, including Florida, have reduced that number. But I still think if it were less than 8, it does default to life. In other words, this idea of the judge making the call, I think, is rare, and I think is only limited to Missouri and Indiana, but very, very perceptive insight there, Mary. Johnny Knoxville for the super chat. Thank you, my friend, says we can't be angrier or more annoyed that when a cold-blooded killer like Kohberger or this guy wants death off the table for punishment. Yeah, I agree with you. I mean, geez, like I said, it's like every parent's worst nightmare. You know, it's almost unheard of, just snatched off of the streets in the middle of the day, broad daylight, and within moments of this, she's been assaulted and a bullet put in the back of her head. Just, yeah, that's the kind of people, putting aside your thoughts on the death penalty for whatever religious, moral views you have on it. If we're going to have it on the books, I always say this is the exact type of monster you want to reserve for. So thank you for that, Taylor. All right, let's keep it rolling here. Where are we going to next?
Hi, Josh. I'm Gosia from Warsaw, capital city of Poland. I wanted to ask the question on the judges and the public to interfere with the proceedings. Recently, Gisela K. had a situation that one of her viewers wrote to the judge, adding her on CC of the email, that the viewer does not appreciate the way how the attorney was asking the questions. And my question is that what kind of consequences the public may have, and if the content creator, Gisela in this case, for sure will not have any issues. Appreciate the response and congrats on the 60K subs. Thank you.
Thank you so much, Gosia from Warsaw, Poland. Is this our first one from Warsaw? Gotta be, right? Okay, good. Maybe even the first one from Poland, or is that another dot down there? Oh, a couple of other ones. Look at that. Poland coming through. Poland showing up. Thank you, Gosia. Interesting question. First, I will say, rule number 1 in law tubery, don't get Gisela in trouble. So just follow that rule and you should be okay. But the story goes, and I don't know, I'm not aware of this, and I haven't talked to Gisela about it, but apparently a viewer emailed the judge and CC'd Gisela on that email. I don't know if that is true, but that's what the caller here is saying. So I'll have to maybe confirm that at another time. And could that get Gisela in trouble? It's not going to get Gisela in trouble, but could it cause the judge to restrict access? You know, we saw that happen in the Barry Morphew case. If it happened in a different case, could it get a judge a little you know, hairy and think that they have to shut down media access and YouTube access, which we all don't want? I think something like that could happen. But listen, these judges, I think that especially this Barry Morphew judge, is being a little overly sensitive to the media attention. You know, you remember in the Barry Morphew case, the judge shut down access in this case, not because a YouTuber was streaming it, but because of the comments being made on a YouTuber's stream, which to me is outrageous. Now you're just simply going after the First Amendment. People are allowed to say what they want to say. My point has always been on this case. This judge now wants to restrict it to, you know, traditional media. And so she's going to allow access to people, media people, to watch it and then report on it. Well, those reports go into articles, and those articles are published online. And guess what happens? They have comments. So people are going to comment on those articles. What if people start saying things that bother her and rub her the wrong way in response to those articles? Is she going to shut that down? Like, this is just another form of the same thing, in my view. I think it was a bit much. And I also would like to point out, you know, get used to the heat, by the way. Sometimes cases have national interest, and sometimes judges are going to get a lot of comments, and the case is going to get a lot of comments. You ever heard of the O.J. Simpson case? You think Judge Ito didn't get some feedback from the public on that case? You ever heard of the Menendez brothers? You think the judge in that case didn't get some feedback from people? It's kind of like, listen, as long as these comments being made by people in the public are not affecting the fairness of what takes place within the four walls of that courtroom, then that's the First Amendment. And we should just allow that to play out. And probably paying a bunch of attention to the noise is not helpful to anyone. That all being said, please don't CC me on any comments that you guys might want to send to the judge or other folks. Just keep me out of it. But Gosha, what an excellent question. Appreciate that. And appreciate you calling in from Poland, and say hello to all your Polish friends there for us. All right, let's keep it moving. I love that. Already we've hopped into Europe. Ali Foley 82 gifted 5 memberships. Thank you so much for that, Ali. Your generosity is greatly appreciated. All right. Here we go.
Hi, Joshua. Hello there. My name's Alan. I'm phoning from southern Spain. My wife, Jenny, is an avid listener of yours, and especially Sunday Fun Day. It's her birthday on Thursday, the 13th of November. So I wonder if you could say hi to Jenny Boardman on this Sunday's Sunday Fun Day. That would absolutely make her birthday complete. Thank you.
Thank you, Alan, from southern Spain. We'll generally put that on the map. This is, everybody, why I shouldn't miss Sunday Fun Days. I missed a birthday shout out. So, to one of my dudes, Alan, I'm considering you part of my dudes. Happy birthday, Jenny, from the whole Courtroom Confidential crew. I hope you're listening today. I'm sorry that I missed your birthday last week. I'm sorry that this is a belated happy birthday to you. November 13th, the day before my birthday and Tiffany's birthday. So happy birthday, everybody. And thank you so much for your support. And a big shout out to Southern Spain. I love it. There we go. Happy birthday, Jenny, says Alicia K. Mayo. All right. That was very sweet of you, Alan. What a nice guy. Let's keep it rolling here. What did I do?
Hello, Joshua, Tiffany, Kaylin, Mods, crew, and Courtroom Confidential family. First of all, congratulations for 60K during the Sunday Fun Day episode. Definitely, you guys deserve it. You're amazing. I am originally from Istanbul, Turkey. My name is Sim, but I live in, and I'm calling from Sarasota, Florida. My mom also loves your show, as do I. I am calling about, well, this is kind of related to the Ellen Greenberg case. Ultimately, that will be the question. I recently saw a 48 Hours episode that was posted on their YouTube, originally broadcast in 2012, but the case itself took place in 1998. This was a young woman whose death initially was ruled as she had done this to herself, but mom was not satisfied with that. Ultimately, she fought for like 10 years, 13 years, and there was an inquest into her death. Just wanted to ask about what that is, first of all, that there's like... it's not like a trial, there's a coroner's arrest or something like that. But could that have been applied in Ellen Greenberg's case?
Sim from Sarasota, Florida. First of all, hello, Sim. And hello, Sim's mom. Thank you guys so much for all your support. Appreciate you calling in. An inquest. First of all, I tried to look for the case you were referencing, and I didn't have enough details to find it. So I apologize for that. But I do know, obviously, about the Ellen Greenberg case. And you're asking, what is an inquest? I think that at least in my understanding, not actually having the details of the case, I think they're just generally saying that an investigation was done, that they reopened up the investigation, looked into the details of that case, which was done in the Ellen Greenberg case. Here's the problem with the Ellen Greenberg case, and I'm about to say some stuff that I think might be frustrating and depressing to everyone listening, including myself. The Ellen Greenberg case, I think, has reached a point where the idea of there being satisfactory resolution for her parents is nearly impossible at this point. And what do I mean by that? I mean that they won this ruling to say, re-examine the case. So if you want to call it that an inquest, if you want to call that a reopening of the investigation, a reevaluation of the investigation, whatever you want to call it, that was done. That was a victory for them. But that was a victory that came with a cost, because when the most recent report came out saying, we believe this was self-harm, we believe we've looked at all the evidence, and we believe our assessment is, in this independent evaluation, we believe that was self-harm. That gave Philadelphia, the state, the police, the prosecutor's office cover. Now no one can point back and say, well, you didn't ever take a good look at it. You didn't ever take an independent review of it. Now, I can already hear you guys. I'm not even reading the comments, but I can already hear you saying, but it wasn't fair. It wasn't independent. They didn't look at everything. They disregarded important information. They skewed things. They had a bias going into. I may agree with all of that. They're going to say, well, that's just your opinion of it. We took an independent and objective evaluation of it, and our conclusion is this. So what position does that leave them in? Unfortunately, that means even if they hire independent examiners, investigators, former prosecutors, whatever they can do from a private citizen's perspective, and say, we have a different opinion. We believe that this was a homicide, and this is the reasons for it, with our medical examination and all these other things. They're going to go, okay, great. Well, that is your opinion. Our opinion is that it's not, and our opinion is that we can't prove a case here. I think that's the way it's going to end up. It's incredibly sad, but the victory was a winning of the battle and losing of the war for, I think, the Greenbergs. I hate to say that. Again, I'm trying to be as helpful to them as possible, but I really do think it might be the end of the road as far as what they could have done on this case. So maybe other people have other ideas. There are plenty of smarter people out there with more creative ideas than mine, but that's the way that I view that. When that report came out, my first thought was that was the cover they were looking for. That is a CYA in paper form, and they're going to say, we've done what we can do. Sorry, folks. Sorry it didn't turn out the way you like. We're moving on to other things. Sim, again, to Sim and Sim's mom, thank you so much for calling in from Sarasota, Florida. Appreciate all of your support. All right. And Jude the Tiger, thank you for gifting a membership. I appreciate that, Jude. All right, here we go.
Hi, Josh and Courtroom Confidential crew. This is Erica from Hattiesburg, Mississippi. I am watching an interview with Dick Harpootlian regarding Alex Murdaugh's appeal and the Hulu series. And he keeps talking about the pleading. He's pled guilty to the financial crimes, and if those wouldn't have been allowed in the first time, then they wouldn't have had all that additional information. I'm a little bit confused because if he gets a new trial, since he's pled guilty to those, wouldn't they still be allowed in regardless? Or would that, as a prior bad act, not be allowed in? I always get that part of things confused, like when is a prior bad act allowed in and when is it not? So just hoping you can help me understand that better. Appreciate you. Thanks so much. Bye.
Erica from Hattiesburg, Mississippi. Let's put you on the map. I love this question, Erica. First of all, that Hulu series is great. Monica Vandenberg says, I agree with you. I should have told Kaylin I wanted to talk about that Hulu series, but if you guys haven't checked it out, it's very good. I just finished the last episode. I know I'm a little bit behind. So did Cap Flap Carnage finish that last episode? I don't even think, do we need spoiler alerts for this? I mean, spoiler alert, he did it. I mean, I don't like, I don't think I need a spoiler alert for this, but it's incredibly well done. I will say they do a good job of making it kind of a mystery, making it, making you kind of wonder towards till the end there. But boy, that last episode was chilling. It was I don't get kind of shocked very often at the visceral nature of TV and film, but this one kind of gives you chills. It's very well done. And the actor, what's that actor's name who plays Alec, is incredible. I mean, it was like, that's how I imagine he is as a person. Anyhow, check it out. But here's Erica's question. Dick Harpootlian, his attorney, they are appealing, and one of the questions being asked is on the use of prior bad acts in the financial crimes that were committed. Remember, the financial crimes case was handled separately from the murder case. He pled, in fact, to federal crimes that put him in prison for close to 3 decades, I think. I mean, he, regardless of what happens in the murder, he's not going anywhere. He's already pled guilty on, millions of dollars in fraud on the financial side. But, and this is an excellent question because it brings up something that we've been talking about recently with Brian Walshe. This is a very similar situation. I've used this case as an example. Because he pled to the financial crimes, does that mean that they're not allowed to use it in his murder case? Well, they did use it in his murder case. So that's one question. The other question is, how are they allowed to use the financial crimes as prior bad acts in this case? And prior bad acts is one of those areas that people constantly kind of get tripped up on and confused by, and it is difficult to understand. It's actually one of my favorite kind of areas of criminal practice because it can be an incredibly powerful tool by the prosecution, but it has to be used in the right way and under very specific circumstances. The best way to think about it is you are allowed to use the prior bad conduct. And it's better, I think, to not think about it as crimes, charged crimes, just prior conduct. Think about prior bad things that somebody has done. Are you allowed to use that? You are allowed to use it if, one, it is relevant. In other words, you can't just say, by the way, Alec Murdaugh had a bunch of parking tickets he never paid. And Alec Murdaugh one time stole candy from a baby. These things are not relevant to the murder trial. So one, as long as they're relevant. And two, as long as you're not using it simply as character evidence to try to say bad people do bad things. He stole a bunch of money from his clients, therefore he's a bad guy, and bad guys murder people, and therefore he murdered his wife and son. That's what you can't do. But you can do it if it's relevant, and if it's relevant, you have to find a reason for why it's relevant. So, can you use it to say common plan or scheme? In other words, That doesn't apply in the Murdaugh case, but you know, you've got prior acts of someone. Say you're talking about a bank robbery, and you show that this person committed prior bank robberies in a very similar way. Therefore, we can use that a common plan or scheme to have committed the bank robbery they're charged with in this case. You're not saying bank robbers rob banks. You're saying he committed crimes very similar to this. Another reason would be, you know, lack of accident. There's a list of things, but a big one is motive. If you can show that the reason they committed these prior bad acts was motive for the crime that they're instantly charged with, then you can use it. And that's exactly why it came in the Alec Murdaugh case. It showed he had a motive. He was stealing a bunch of money from clients, and that was soon to be discovered. He had a bunch of financial stress upon him. His son had killed a young girl in a boating accident. There was a bunch of financial stress and pressure from that. And because of all of that, he saw his only way out was to murder his wife and son. There is the theory, there's the relevance, and there's the motive, making it not character evidence, meaning that they can bring in that prior conduct, prior bad acts, prior bad conduct into the trial. Same with Brian Walshe. He pled guilty to misleading police. He pled guilty to conveying of her body, meaning disposing of her body. Does that mean that because he pled guilty to it, it doesn't come in? No, as long as it's relevant, you can use that conduct. So is it relevant to the murder case that he hid her body and lied to police? I think absolutely yes. They're going to get all of that in. So great question, Erica. And I hope that explains prior bad acts a little bit better. But the general rule is you just can't use it to dirty somebody up. So thank you so much, Erica from Hattiesburg. What is going on with my thing here? I don't know why this is looking like this to me. Hold on. Okay, everybody calm down. We're all good here. Oh, and Joy W. Can, thank you so much for gifting the members, or gifting the coffees to the mods. Appreciate that. Therapist, you know, with a super chat. Thanks for the brains and heart you bring every week. Oh, that's very sweet. I'm going to attribute that to me, the brains and the heart, and maybe you were directing that towards Kaylin and Tiffany, in which case, still thank you. All right, where are we at here? Erica, Micah. Here we go.
Hey, Josh. Micah from Hurricane, West Virginia here. One of your 10%ers. I wanted to get your reaction onto the deep dive investigation that John Oliver just did this past weekend about felony murder and the charges essentially that felony murder have come along with and how it can be charged. According to the reporting, it seems like there's a lot of overcharging when it comes to felony murder. And it seems like it's just disproportionately, what's the best way to say it? Racially charged. Wanted to hear your thoughts on that. Also, shout out, Shy Gal. You're the best mod ever. Sonia, forever and ever, you're the best.
Ah, that's very sweet. Micah from Hurricane, West Virginia. One of my dudes. I love it. Good to hear from you, my friend. I think that's the first time that you've called in. And what a great question. Shy Gal says it's a great question too. I did not see the John Oliver segment, but I read an article about it and kind of the points that he made. And no offense to John Oliver, but these arguments have been made for some time about the felony murder rule. And I think these arguments, for the most part, lack the perspective and insight in how the felony murder rule is used in practice. I'm going to tell you about the felony murder rule, how I saw it used in practice. And I don't think Los Angeles County is entirely off the map as far as how it's applied in most jurisdictions, the felony rule, that's the felony murder rule, that for jurisdictions that still have it. By the way, in California, they've repealed it to some extent. But at its basic form, the felony murder rule says that a murder taking place during the commission of certain felonies, anyone involved in that underlying felony can be charged with the murder. What do we mean by this? We mean if 3 dudes arm themselves and go into a liquor store to rob the liquor store, and one person shoots and kills the clerk, the other 2 guys can be on the hook for murder. Why? Because in the commission of an armed robbery, a murder was committed, and therefore they're on the hook, according to the felony murder rule, for the murder. And you might say, well, they didn't pull the trigger. Well, what the law says is, listen, if you are going to commit certain crimes that are so inherently dangerous, robbery, the R word, burglary, residential burglary, people present, kidnapping, arson, things that are so inherently dangerous that the risk of death is so high, you cannot then hide behind the idea of, well, I didn't mean to kill anybody. I was just trying to light a house on fire with people inside of it. I didn't mean to kill anybody. I just mean to go into a liquor store with a loaded gun and point it at a clerk. That's where we say, listen, those arguments fall short. So what the felony murder rule does is it substitutes the intent to murder, which might be difficult in some cases. All I meant to do was light the house on fire. You have no proof I meant to kill. And substitutes that intent to commit the felony for the intent to commit the murder. And therefore you get yourself to a murder case. Now, where folks like John Oliver like to attack this is they take that and they go, well, let's bring that to its most illogical end. What if you're the getaway driver for a robbery and the guys go into the store and you don't even know that they're armed, and they go into the store and somebody gets killed? Now you, the poor jerk who just happened to be outside of the store in the getaway car, now you're looking at murder charges. Is that the grand end of the whole thing? I guess if you think about it from its most basic applications, it could be. Does that, and that's why I say in practice, happen? No. In practice, no. In practice, where it happens is in the situations like I'm telling you, where somebody is participating in incredibly dangerous conduct, incredibly violent, high risk of human life being lost conduct. Again, not to get incredibly graphic about this, but think about a person who commits the R word, and in the commission of that, that victim dies. Are we going to not hook them for murder because they can say, all I intended to do was assault this person? No. So when you talk about, we need to repeal it, we need to get rid of the felony murder rule, those are also the consequences that you're talking about as well. I think it is better applied in a very judicious manner and putting the discretion in the hands of the prosecutors who are handling these cases and can have some insights into when it should be applied and when it doesn't. But when the John Olivers of the world, who I don't know if he's ever stepped foot inside of a criminal courthouse, start to point at the illogical conclusions of all of this, people get kind of worked up about the whole thing. In California, though, because of those kind of same arguments that he's making, they repealed it. Right now in California, you cannot charge, in my example of the 3 guys, all of them armed, go into a liquor store. Let's say all of them fire at the liquor store owner and only one of them hits them. The other 2 are not going to get charged with murder. It's only the person who actually committed the murder will get charged with murder, and the other two will get what? An attempt murder, an armed robbery. I don't think that is the serving justice at the end either, but that's the way that the law stands in California right now. So excellent question, Micah. I really appreciate you bringing that. I don't know when else we would have had an opportunity to discuss that. So I appreciate you bringing that up. Hello to Hurricane, West Virginia, and hello to one of my dudes. We got to get like a flashing my dude sticker. All right, let's keep it rolling here. Thank you to the anonymous gifter for buying mod coffees. Oh, anonymous gifter. Maybe that was me. OnlyFan has been a member for 4 months, everybody. Golf clap for OnlyFan. One of only 3 channels I joined memberships. Oh, that makes me feel fantastic. Thank you so much. We appreciate that. What high praise. All right, let's keep it rolling here.
Hey, Josh and CC crew. This is Sneemac calling from Alexandria, Virginia. But when you get this, I'll actually be in Ho Chi Minh City, Vietnam, and I have a return ticket for those of you wondering. This case I want to get your insight on is different than the red rum cases that we usually discuss, and it's probably a term you haven't heard since law school. It's an alienation of affection case out of North Carolina, which is one of the few states that still has this on the books. And it's between plaintiff Akira Montague and defendant and TikTok influencer Brenay Kennard. Akira's suing Brenay for stealing her husband, which is it was a crazy case, especially since the husband took the stand and said some stuff that was, I'll let you deliver what he said. It's not very nice. And the surprise verdict, and also just crazy to prove, but for another woman, I would still be happily married. That's just a crazy legal premise. So, and also to put a price on damages. I don't know. I've been married 31 years, so most days I pay someone else to take them off my hands. But am I right, ladies? But anyway, yeah, it's just a crazy case, and I'm still giggling, and my mouth is still on the floor over it. So happy Sunday Fun Day.
That is funny. Sneemac from Alexandria, Virginia. Well, according to the bylaws of Sunday Fun Day, we are going to put your dot on the map as to where you domicile. So there's Alexandria, Virginia, but you are, I hope right now, having a wonderful trip in Vietnam, and you sent us a picture here, and I love this. This is from Ho Chi Minh City in Vietnam. Are we able to zoom in, Kaylin? I just want you all to get it low. There we go. Look at that shirt representing in Vietnam. I recognize that logo. Thank you so much, C-Mac. That is so very kind of you, and I love that you're representing your crew in Southeast Asia there. We almost made it to Vietnam one year, and I'm still regretting that we didn't just go over there. We went to Thailand and Singapore, but we didn't make it to Vietnam, and I hear that it's absolutely gorgeous. So I hope you're having a wonderful time, and please send us more pictures. And what a great question. I had not heard about this question. Alienation of affection. I vaguely remember those words being tossed around in law school, but this is a wild story. So there is a TikTok influencer by the name of Brenay Kennard. That's her. Her manager was a woman by the name of Akira Montague. Akira was married. There's Akira, married to Tim Montague. He's right there on the right. Look at how happy that couple is. Well, not so much, because according to Akira's lawsuit, Brenay got involved and started alienating with her affection. What does that mean? It means she was trying to cause trouble in their marriage. The story is a little more complex than that, because Akira says that Brenay befriended her and started to get kind of insider information about her relationship with her husband, and then used that information to try to drive a wedge between them, because she wanted, there she is, There's Brenay with Tim. She wanted Tim. And she did break up their marriage. She used such amorous tactics as flirting with him, wearing short skirts and bending over in front of him, ooh la loo, and exposing her tongue ring to him. Yeesh. Whatever it did, her feminine wiles seduced poor Tim. I love that in all of this, it's like Tim is just this hapless schmo who, I got my wife. Oh, wait a minute. Here's a lady with a tongue ring over here. In any case, the jury bought it and awarded Akira $1.75 million. There she is, hugging her attorney and happy. She's no longer with Tim, but she's got 1.75 million reasons to not really care anymore. This would be a great Jerry Springer episode. Just a wild, wild, wild case. And sad, but also kind of funny. And I hope Akira's doing well now. And you know what? I hope Brenay and Tim are having a good life as well. 1.7 million less wealthy, but apparently I need to get into TikToking because that's where the real money's at. But anyhow, but this made me think of this, and I want you, Sneemac, to do a little research on the Ben Zobrist case. You guys may remember this one. He was an absolute star baseball player for the Chicago Cubs. Maybe Shy Gal remembers. And he was married to Juliana Zobrist. There they are there. This is also a scandalous story. They were having some marital issues. He actually stepped away from baseball to give attention to his marriage. And they went to see their pastor as a counselor. Their pastor's name was Byron Yuan. And then he finds out that Juliana has been sleeping around with Byron all the time that they were seeking counseling together. So just absolutely wild. Ben, poor guy, sues. I don't think it's one of the similar lawsuits, but he ends up divorcing her. And I think she even tried to make some sort of argument that in the divorce proceedings that she that him stepping away from baseball, she should be compensated for. I don't know, something wild like that. But anyhow, Sneemac, I expect a full report from you when you return from Vietnam on the Ben Zobrist case. Just another horrible case. Don't mess around, people. Don't mess with marriages. Johnny Knoxville says you can soothe my broken heart for less than 1.75. I imagine so. Imagine a lot of people would pretty easily get over their problems for 1.75 million. CR Confidential, I've heard of them, has gifted 5 memberships. So whoever receives those, please enjoy. I think you will have a as you can tell from Tumwater Troy, who's been a member for 3 months. It's a good time over here. Ta-da, says Tumwater Troy. All right. Thank you for that, Sneemac, and have fun in Vietnam. All right, let's keep it rolling here.
Hello, this is Krista J. from Sandy, Utah. Larry David has a show called Curb Your Enthusiasm. In season 4, episode 6, Larry is trying to get to a Dodgers game. Well, that show is also associated with another show on Netflix called, or not a show, a documentary called Long Shot, where a man is accused of murder and his alibi is that he was at a Dodgers game. Well, the defendant, Juan Catalan, I believe, his attorneys are looking to corroborate his alibi, and they ultimately find out that the filming of Larry David's show was the same day of him attending the Dodgers game with his daughter. I'm sure Kaylin can find more details on this, but I find this really a fascinating story, and I wanted to share it simply because the Dodgers have won the World Series, and I thought you might enjoy looking into this. Enjoy your day.
The Dodger, I just caught that last part of your comment, Krista J. The Dodgers won the World Series. I think that's right. I think that's 2 years in a row that they've done that incredible feat. Thank you so much, Krista J. from Sandy, Utah. Let's put you on the map there. This was a wild case. And yeah, it's a really good documentary. You guys should check it out. It's called Long Shot on Netflix. There it is. Pretty easy enough to find. So Krista did a great job of explaining this, but I'll just kind of go over it again. Juan Catalan, who's pictured there, is accused of murdering a woman by the name of Martha Puebla back in August of 2003. The motive for that murder was that she had been a witness in Juan's brother's trial. So she testified against Juan's brother. There's a lot of allegations of gang membership and activity here, and that the motive theory for the prosecution was that Juan, to get revenge for his brother and for the gang, murdered Martha Puebla. Well, this took place on an evening in Los Angeles that also happened to be the evening of a Dodger game. Juan says, I couldn't have committed this murder. I've got an alibi. I was at a Dodger game. Great. Where's your ticket? Don't got it. Great. Where's proof you were there? Don't got it. Well, this is his attorney, who I'm blanking on his name. They say, what else can you tell us about this Dodger game? Well, I remember they were filming an episode with that Larry David guy, Curb Your Enthusiasm. So his attorneys go to the producers of that show and they say, can we get your footage from the night that you were there? Because they actually, this wasn't like a situation where they staged a game and, filmed it when there wasn't a game happening. They actually filmed this while a game was happening, just put cameras in the seats and filmed this so people knew something was being filmed. And lo and behold, during that game, there's a picture of Juan Catalan at the Dodger game. So they go back to the judge, and the judge, based upon this evidence, dismisses the case. And it's this kind of wonderful hero story. Well, there might be another side to this whole thing. The prosecutor on that case objected to all of this. Her name, you may recognize her, is Beth Silverman. Beth Silverman was a colleague of mine when I was in the DA's office. Beth's story is that, okay, he was, and you may remember Beth, she prosecuted most recently Monica Cementelli. So if you followed that case, for Monica is accused of murdering her husband, Fabio. If you followed that case, Beth was the prosecutor. She's a real aggressive, accomplished, very good prosecutor. Not somebody to mess around with, and certainly not somebody who gets things wrong or ignores evidence. Beth's point was, yeah, he was at the game. The murder took place an hour later. Who says two things can't be true? Beth's position, and the position taken by the prosecutor's office, in spite of the judge's ruling, was that, yeah, he had himself a Dodger dog, and then he got out of there and went to a location not all that far away from Dodger Stadium and committed this murder. So, that all being said, I'm just reporting to you the facts. It wasn't an acquittal. It wasn't a trial. He had his charges dismissed by a judge. Watch the documentary. Enjoy it. It is a fascinating story. But now you know every coin has a couple of sides to it. So thank you so much for that, Krista J. from Sandy, Utah, for bringing that to our attention. Very fascinating case. And you know what? Here's what I'll say too. I applaud the work of that attorney. That is digging deep, right? That is not just, well, sorry, dude. Sorry, Juan. We can't, unless you can provide me with the ticket. He said, no, let's take a shot. Let's see if there's a chance. And lo and behold, I mean, you can imagine that moment when they discovered their client in the background of this one shot from some B footage of the Larry David show, the Curb Your Enthusiasm. Attorney Todd Melnick. That's it. All right. Thank you for that, Kaylin. Kaylin knows everything. She's an encyclopedia. All right. Let's move it along here.
Hi, Josh, CC crew, mods, Tiff, and Kaylin. This is Callie from St. Mary's, Georgia, aka Southern Cali B. I was watching the William Kelly trial a couple weeks past. William Kelly is on trial for the murder of his longtime girlfriend and unborn baby girl. During the trial, a trooper testified as to William Kelly. He stated he sat with him because Mr. Kelly was advised of his Miranda rights. However, wouldn't make a statement until he was appointed a lawyer. This caused a bit of chaos in the courtroom, and actually his statement ended up leading to this trial being deemed a mistrial. Can you please explain this process in regular terms to help me understand? Why would a statement like this cause a whole mistrial? I look forward to hearing your thoughts on this. Thank you for all you do.
Callie from St. Mary's, Georgia. Let's put you on the map, St. Mary's. Thank you so much for calling in. This is an incredible a point that we actually covered on last week's, I think, weekly roundup, because I thought this was fascinating as well. It is a legal doctrine that should be very clearly understood by both prosecutors and law enforcement, because it can lead to dire consequences like this. I also want to give a shout out to Faye from Buffalo, New York. We had a lot of questions to get through this week, and I appreciate you guys calling in, and I wish I could answer every single one of them. But we just didn't have time. So Faye also asked a very similar question to this. So I shout out to the two of you. William Kelly, accused of murdering Christine Falzone. The judge declares a mistrial, which is in the middle of trial, which is very rare. Asking for mistrials by defense attorneys happens all the time. Being granted by judges, nearly unheard of. I have never had a mistrial declared in the middle of a trial I've ever done. And I'm trying to think of an example where I knew someone who even had that happen. I cannot think of an example. I mean, there might have been, but nothing's coming to my head right now. It's very, very rare, because it has to be something so bad that the judge cannot cure it through an instruction. And judges feel that they can cure damn near anything with an instruction, which is sometimes very frustrating to the parties, because there's this concept of you can't unring the bell. You can't, jurors are not AI yet. You can't just tell them, forget about what you just heard. In fact, I think there's an argument to be made when you tell jurors, forget about what you just heard, disregard what you just heard. They're probably going to think about and regard what they just heard more than anything else, because they've been half asleep through the trial anyways. So what happens here is a trooper gets on the stand and testifies that after having, his name is Charles Brooks, Trooper Charles Brooks, after having advised Kelly of his Miranda rights, which is important, a triggering event, he testifies that after having advised him, he refused to speak until his attorney was present. Big no-no. If there were sirens and lights in a courtroom, they would all go off right then and there. This is a big violation, and there is long precedent of constitutional law to support this. But going back to a case from 1965 called Griffin versus California, this is Griffin error, we would refer to it as. And Griffin error is about one of the worst things you can do as a prosecutor. And even though the prosecutor didn't do it, the prosecutor should have talked to everybody ahead of time about not doing this, because they knew this issue was lingering out there. Whenever you've got somebody that you're going to be asking them about the arrest of the defendant, and the defendant invoked his fifth, you got to make sure nobody touches that. It's a third rail situation. But it all goes back to the Fifth Amendment in this case, Griffin versus California. Supreme Court said essentially that commenting on a person's invocation of their Fifth Amendment rights, quote, cuts down the privilege by making its assertion costly, meaning you are essentially using their Fifth Amendment right against them. By telling people he didn't want to talk after I advised him of his Miranda rights, you're essentially telling jurors that person's got stuff to say that's probably implicating to him. And they're going to make an adverse inference from that assertion of the rights. And we have said, and it makes absolute sense, that's a big no-no. The Fifth Amendment is one of our cornerstones of criminal jurisprudence, and it says people have a right to not testify against themselves. They don't have to say anything. And if you're using a constitutional right, you shouldn't be punished for that. So when that came up in court, he was advised and said he didn't have anything to say till his attorney got there. The judge did the right thing. That cannot be cured. This would have been appealed in a heartbeat, and it would have been a complete waste of time. The judge did the right thing. Now there's Kelly celebrating, but this is a Pyrrhic victory because he's going to be, I think the judge already reset this. It's already going back to trial. They're just going to do the whole darn thing all over again with a new set of jurors and avoid this issue. That was the problem, is they simply could not unring this bell with any kind of instruction. If the judge had, it would have been appealed. So good on the judge, bad on the prosecutor and the cop. The cop should have known better too. These cops are not lawyers, but it's like they are trained on basic things on how to testify. And this is, I'm sure, day one. I'm not trying to say they're bad guys. I'm just saying this was a big, big boo-boo. So thank you for bringing that up, Callie and Faye. Excellent question. But that's what happened with that case. But it's just going to come right back around. All right. December 9th. Is that when the trial's starting? Look at this. Look at this. Real-time updates from Courtroom Confidential. All right. What do we got next here?
Well, happy Sunday, Joshua, Tiffany, Kaylin, mods, crew, guests, everyone. It's Alicia K. Mayo from Humboldt, Tennessee. Joshua, you've been covering some heavy, heavy cases lately. I thought we all might need a little bit of a reprieve from that. I came across an interesting term the other day, and I did a bit of research on the internet, and pretty much all ended up with a unsatisfactory answer. Can you explain a ghost warrant? I'd like to know more about it because from what I found, it seems to be pretty much a filing error, possibly made by a clerk, but not only a clerk could be at fault. I would hate to think of someone being arrested or facing an arrest for a charge that was dismissed or cleared, or they might even serve some time for up to years ago. Look forward to your answer as always. I do hope you and the lovely Miss Tiffany had a delightful and fabulous shared birthday the other day. And as always, happy Sunday Funny, y'all. Thanks. Bye.
Alicia K. Mayo from Humboldt, Tennessee. It's like I just have this. It's like muscle memory at this point. Alicia K. Mayo, Humboldt, Tennessee. Great question. What is a ghost warrant? It's funny. I've never heard this term actually used, but I've dealt with these many, many times in my career. I mean, the best way of describing it is a clerical error. Essentially, somebody got put into the system. A warrant was issued. That warrant got cleared through the courts, but that clearing of the warrant never got entered into the system. And this does happen. I mean, listen, the court systems handle hundreds of thousands of appearances every single year, dealing with thousands and thousands of different defendants. And it's all coming down to clerks in every courtroom entering that information properly. And sometimes things get missed. Now, I have not seen this happen in very serious cases. Like I've never seen somebody get brought in on a bad warrant for murder. But I have seen it for, things like failures to appear in court or, violations of probation and warrants get issued. Most times, the way it works is a person gets pulled over in their car. The cop is running their plates, says, stop speeding. And by the way, you have a warrant. You should go get that checked out. Not every warrant are they going to lock you up. It's only if the warrant is for a certain amount of money will they actually bring you into custody. So what happens is those people come into court and they're all like, what is it? I got this warrant, but I didn't do anything. I did everything. And you run their record and you find out, oh yeah, they did satisfy all the obligations of their probation, or they did show up to court, and they do what's called issuing a recall and quashing of that warrant. And it just clears it up, gets it out of the system. But it does happen. However, in the vein of breaking news always being brought to you as it happens here on Courtroom Confidential, the fastest growing true crime news channel on YouTube, you know who doesn't have a ghost warrant, who has a real warrant out for them, is Morgan Geyser. You may remember her. She is the young lady who's not young anymore, who took part in the Slender Man attempted killings. She was in the news recently because she was trying to be released from her treatment home. And there was a lot of concern about whether or not she was well enough. And it kind of went back and forth with the judge. Well, somebody made the wrong decision. And the reports are that she actually cut off her ankle monitor and it has escaped from her group home. Bad news. I don't know if Slender Man is talking to her again. I hope she doesn't commit acts of violence. I hope she is brought in safely. But this is why people who are unwell should probably not always be given the benefit of the doubt and likely do continue to need treatment, if not for the safety of others, for their own safety. This is a recent image of her captured on security video this past month. See that? Breaking news here at Courtroom Confidential. We need a breaking news banner, a swipe. I want to swipe, Kaylin, next time. Full-throated motion says, oh yeah, that case. Well, that's less than good. That is correct. That is what we would call less than ideal. Court Lurker says, saw this coming. It was too soon. Yeah. She did not look well in court. And there was all this evidence that she's like researching bizarre things while she was in. She's just an unwell person. She needs treatment. What if, put it to you this way, what if she gets harmed herself? What if they try to bring her in and something horrible happens? I mean, that's, it's not even just public safety or her own safety. She's obviously not well. All right, Alicia K. Mayo, thank you for the question and for sparking the conversation about Slender Man. You guys didn't see that one coming. Are we having a good time, by the way? Happy Sunday Fun Day from Annalie Finch. Thank you so much for the super chat. We're talking about William Kelly. We're talking about Long Shot documentary and Curb Your Enthusiasm. John Oliver made an appearance. A lot of good stuff today. Cat Flap Carnage has been a member for 2 months, everybody. Golf clap for Cat Flap. Golf clap for Cat Flap. Rocking my new CC merch for Sunday Fun Day. I love it. Oh, is that a picture? There you go. I love it. Thank you for that, Cat Flap. And now I've lost my spot completely, but everybody's having a good time and everybody's juiced. There we go. Now I found my spot. All right, let's keep it rolling here.
Hello, Josh and CC crew. This is Momo calling from Portland, Oregon. And I have a question that, I don't know, maybe it's kind of a basic question, but the more I thought about it, the more I was like kind of wondering. It's about, a defendant choosing to testify. I'm just kind of wondering like how the scope is reconciled when it comes to cross, because so this is just my understanding. I'm like a layman, I just like watching court. So the cross has to be in the scope of the direct, unless the parties have some kind of agreement that they can go beyond the scope in order to save time from having to like recall witnesses and, just like judicial economy, as they call it, right? But so when the defendant chooses to take the stand, obviously, there's all the colloquy, stuff like that. But a lot of the time, like they'll say in the colloquy, you can be questioned on anything pretty much. So I'm just wondering, like, why is the scope unlimited in the cross of a defendant when it's not necessarily like that for other witnesses, to my understanding? I mean, maybe I'm getting some of these little details wrong. I'm just kind of gathering from what I watch, but I hope you can shed a little bit of light on the topic for me. Thank you.
Momo calling from Portland, Oregon. Again, further establishing my point that this is the smartest community on YouTube. What an excellent question. And you analyzed that perfectly. So I'm just going to basically say what you just said, Momo. But you're right. Let's first of all talk about scope of cross-examination. The scope of cross-examination is supposed to be limited to the scope of direct. And what does that mean and why is that? Well, if you're asking a police officer about their investigation, you don't want cross-examination including everything that cop has ever done ever, if it's irrelevant to the proceedings, right? Same with civilian witnesses. You call a witness to say, I witnessed a liquor store robbery, and that person sitting over there was one of the people who was there. You don't then get to ask them, well, what were you doing at the liquor store? Or how often you go that? I mean, there's just some things that are just fall outside of the scope of direct. Judges will give some leeway on cross. This is that moment you'll see in TV where they're like, Your Honor, if I could just explore this for a moment, the relevance will become clear. But for the most part, they're kept on a fairly short leash. Now, that all being said, the same rules apply when a defendant takes the stand. You can't just get into completely irrelevant things. But for every person who takes the stand, their veracity is always at issue. Are you a person who shouldn't be trusted? And do we have reasons to not trust what you're saying? So if your veracity is at issue, other things might come in. Felony convictions. You take the stand. I'm going to ask you, have you ever been convicted of a felony? We're going to get into all of those felonies that you've been convicted of. Crimes of moral turpitude that might not even be felonies. Things that show that you are not entirely a person who is trustworthy. I'm going to get into. I get to ask about. The rules still apply. It's just the relevance is broadened when it happens to be the defendant, because the defendant is the person saying, I didn't do this. And they're going to have some story to tell as to why they didn't do it, which can open up and broaden the relevance of questions that they're going to be asked by the prosecutor on cross-examination. But that still means there's a limit to it. It's not unlimited. A prosecutor can't get up there and go, and by the way, weren't you mean to your sister in the 6th grade? It has to somehow relate to the crime being charged here. But it is if you want to talk about the leeway given to a prosecutor when the defendant has testified, it's fairly broad leeway. I hope that clears things up. Momo, great question. But that's another reason why taking the stand as the defendant is an incredibly difficult thing to do. It doesn't always have to do with innocent people versus guilty people. One of the most frustrating things to me is when I would do jury selection, and you would indubitably have a person raise their hand and say, well, I can't believe someone who wouldn't testify, because if I were accused of a crime, I would testify. Nah, would you? Would you though? Would you be able to get up on the stand and put up with cross-examination and have, every little thing that you've ever said ever micro-analyzed, and every comment that you ever made to police, if it was slightly different from the comment before, completely twisted into being the biggest lie that was ever told. And, you know, it's difficult to sit there, even as a completely innocent person, and put up with the crucible of cross-examination. So let's just afford everybody their presumption of innocence and the ability to not testify. All right, great question. Let's move it along here. Here we go.
Hi, Josh. Hi, mods. Hi, CC crew. It's Little Miss Red Velvet again. Maybe this is for next week. This is about the Carnival Cruise and Anna Kepner, the 18-year-old. Because she's on a cruise, I thought Josh could maybe talk about the Death on the High Seas Act, because the FBI has jurisdiction because it's in international waters, but did leave out of Miami. At present, the investigation is ongoing. They don't know what has happened to her or when, but they do have a captive audience to investigate and to also interview. The cruise is under the Canadian flag, and the laws apply at sea, which is going back to the Death on the High Seas Act if it does prove to be a homicide. I just thought it was an interesting case. See you all Sunday, CC crew. Bye.
Little Miss Red Velvet from Manchester, England. Let's put you on the map. Always a pleasure to hear from you. And what an excellent question. This case is getting a lot of attention, and it's really starting to, with each new development that comes out, it's starting to get more and more sinister. And I think we're definitely dealing with a murder. And it looks like it might be a murder at the hands of her stepbrother, who is only 16 years old. So none of that has been officially released by law enforcement, but we're just getting tidbits of information here or there from sources. But it's all sounding very, very awful. But it's also a case with some fascinating legal concepts to talk about. And one of those is what Little Miss Red Velvet brings up. Who exactly has jurisdiction for a crime that takes place in the middle of the ocean? And you bring up the Death on the High Seas Act. I love that. It sounds like, you know, pirate law. The Death on the High Seas Act from 1920, by the way. Maritime law is also some of the oldest established law. Really has to do with civil aspects and wrongful death actions. It's the wrongful death statute for deaths that take place on the high seas. So who can you sue? How can you go after them? Who has jurisdiction? Which court do you sue out of? Yes, it has a lot to do with, you know, how far away are you in coastal waters? Whose flag is the ship flying under? Things like that. The special maritime and territorial jurisdiction of the United States is what applies here from a criminal perspective, which gives the feds jurisdiction over this case, which is why the FBI is investigating it. That applies in all cases with either a ship that is flying, sailing under a U.S. flag, or a ship that is either departing from or arriving at a U.S. port, which I thought was interesting, or a crime committed by or against a U.S. national. So regardless of where this ship was sailing and regardless of who it's flagged under, the feds would still have jurisdiction here to prosecute within the U.S., just so that you understand. Because it's involving U.S. citizens and because it took place on the high seas, that's where the feds step in and they say, well, we're going to handle this from a criminal investigation and criminal prosecution perspective. And like I said, it is looking much more like it is a crime. Initially, you know, it is amazing how this story has advanced. Initially, it was tragic story, young girl, 18 years old, found dead on a boat. How sad. Then it was found wrapped in blankets, stuffed under the bed with life preservers on top of her. Oh my God. Now it's looking like somebody was involved in hiding of her body, but no cause and manner of death. Now we know that there's a criminal investigation. Now we know that the stepbrother is being looked at. And now the latest that we're finding out from reports is that she had bruising around her neck, and the likely cause of death was asphyxiation. The ex-boyfriend of Anna has come forward and said that he had reason to suspect the stepbrother. They may have had a prior inappropriate relationship, whatever it is. Bad stuff, bad news. So now we're getting into that territory of, is he going to be arrested? Is he going to be prosecuted? Is he going to be tried as an adult? Really, really horrible stuff here. So a tragedy for that family and a tragedy for both sides of that family now. In that case, like I said, we're going to keep a very close eye on it because I know it is something that a lot of you are interested in. All right. Thank you for that, Little Miss Red Velvet. Let's keep it rolling here.
Hi guys, it's Jody from South Florida, and I have a little ditty for you. Tiptoe through the crime scene, through the courtroom, and follow Josh. Just tiptoe through the crime scene with us. Courtroom confidential is essential for all of true crime. Tiptoe through the crime scene with us. I do have a question, and that is, Josh, what is your most memorable case, good or bad, while you were a prosecutor with the LA District Attorney's Office? I do love a good story time. Thanks, guys. Love you all.
Jody, you are an absolute treasure. That was fantastic. Thank you so much for that. You knew something good was going to happen when you heard the first couple of strings being plucked on that ukulele. Jody Arrington from Florida, let's put you on the map. Thank you so much. That really put me in a fantastic mood. What is my most memorable case? You know, I don't know if this is like the case that I talk about all the time, all that much, but it's the first thing that came to mind when you said that to me. And it's pretty clear why when I'm about to tell you the quick version of it. But I handled a murder case that took place in South Central LA. It was this mother and daughter, no father involved, living in this house. And it was one of these kind of houses that had kind of been converted into a makeshift multi-person living situation. Everybody was in a different room. They were all renting. They didn't know each other. The living rooms converted into a bedroom as well. All very low income, very, very sad kind of living situation for this mother and daughter. And one of the men who lived there had prior history of violence. And I forget now what the reason for it was, but he got into it with the mother. He pulls a gun, and while the mother's in her bedroom with her daughter, shoots randomly into the bedroom, shoots mom, kills mom in front of daughter, and daughter takes off running outside of the house. She's young. I want to say she's 12, something like that. She's calling 911 on I think her mom's phone. And we had the 911 tape. And it's just heartbreaking because she is so scared and she doesn't know if the guy is chasing after her. And she testified at the murder trial of her mother and told this story and she just was incredibly brave. And I remember just, it was one of those moments where the jurors are dabbing their eyes and the detectives are, getting teary-eyed, and I'm having trouble kind of keeping it all together, because it was just to see this incredible bravery of this young girl who had not had a great life, and now it was made all that much worse. And she was still brave enough to get on the stand and testify against this, real piece of work. He ends up running into his room and like superficially stabbing himself in the legs to make it look like he was trying to kill himself, and ends up getting arrested and making a bunch of admissions. And we got a conviction out of the whole thing. But that was a case that, I don't know if it's like, you asked me what's my most memorable, but for whatever reason, when you asked me that was the first case that came to mind. Real tragic case, really sad. Yeah, I'm not crying. You're crying. Everybody's crying. One of those situations. Thank you for that, Jody, for the song and for the question. Laura Waldy, thank you so much for gifting a membership. Appreciate you. And Kathleen Craghead has been a member for 4 months, everybody. Happy Sunday Fun Day, she says. Well, happy Sunday Fun Day right back at you. All right, let's keep it rolling here.
Hey guys, it's courtroom junkie Katie R, aka Katie Russin from Fort Smith, Arkansas. I just watched your birthday video and I cried with all of the members sending love, and Gizla and Recovery Addict. It made my whole day. I am a little upset that I didn't see that, because I 100% would have sent a message, but I have 3 teenage daughters and they keep me quite active and busy. But the one thing that makes my life a little bit less crazy is getting to listen to y'all each day. Thank you for all you do, and happy birthday to both of you.
Oh, Katie from Fort Smith, Arkansas. That's so very sweet of you. Let's put you on the map. Thank you so much for just the kind words. You're also making me nervous. You got 3 teenage daughters, and I was told at one point it might get easier, but it sounds like it just gets tougher and tougher. All 3 of them were yelling at me this morning. I can still hear them in the house yelling somewhere. It's just, I'm hiding down in my little podcast dungeon. But thank you so much, Katie, for the kind wishes and for the birthday wishes. And yes, that birthday video was an absolute treat, and it had Tiffany in puddles. So thank you to everybody who took part in all of that. It was very, very kind of you. All right, let's keep it rolling here.
Hi, Josh and CC crew. This is Misbehaving from Nottingham. I was wondering, with all the clamour of will they, won't they arrest Wendi Adelson after each grand jury sitting, should they decide there is enough evidence, how long can prosecutors hold on to an indictment before they have to act on it? Thanks again for the time to answer my question. Ta-ta now.
Misbehaving from Nottingham, England. Let's put you on the map. Great question. Very interesting question. So, what Misbehaving is asking is, let's say, hypothetically, and we don't have any information that this has been done, let's say that they have convened a grand jury, and we wouldn't know if it was being done, by the way. It would all be secret. They had convened a grand jury on Wendi Adelson and received an indictment for her, but didn't do anything about it immediately. How long can they sit on that indictment? In other words, does an indictment have a shelf life? And that's a very interesting question. Mainly because you don't see it happen all that often, that they would wait. Usually, if they're convening a grand jury and they get an indictment, they want to arrest that person and have them arraigned on that indictment as quickly as possible, because, the information in an indictment may not last all that long. In other words, you've got witnesses who testified, but are they going to be reluctant to testify later on? You have the evidence together. A grand jury has said you've got enough for an indictment. You usually want to act upon that. But the interesting answer to that question is you don't have any time limit as far as the indictment itself doesn't go old. In other words, So year down the line, that indictment's still good. You don't have to re-up your indictment and get a grand jury again. The only thing preventing you is the statute of limitations, obviously. So, you know, in certain types of crimes where there is a statute, just because you got an indictment doesn't relieve that statute. You actually have to go charge that person. That is what clears you for the statute of limitations. In murder cases, though, it's unlimited. So they could sit on this. If it's a murder indictment, they could sit on it as long as they want. I don't think they would, but they could. But the way it works is that before charging someone, you're dealing with statute of limitations. That's your deadline. After charging someone and before arraignment, so in other words, this happens sometimes, by the way, a case might be filed for warrant. So police bring in police reports to the DA. The DA says, yes, that this person's not in custody, though. Okay. So when a person's arrested and they're in custody, usually you have 48 hours or so to arraign that person. But if the police don't make an arrest, they're just doing an investigation and they've identified a suspect and they hand that over to the prosecutors will file a warrant, a complaint based upon a warrant. Now it's on the cops to go out and arrest that person and bring them in to be arraigned. If the cops wait on that for whatever reason, they don't go to really try to find this person. They're kind of lazy about it. They forget about it. At a year or so down the line, then they arrest that person, or then they tell that person they need to show up to court. There is a case called Cerna out of California. There's other jurisdictions have similar cases, though, which basically say that, hey, that delay post-charging and prior to arraignment, that has prejudiced the defendant. And you cannot just be lazy, law enforcement, because now that defendant may have lost evidence, may have lost witnesses, just because you couldn't trouble yourself to go out and find them quick enough. And then after arraignment, now that person's been arrested, they've been arraigned, you're just dealing with your normal speedy trial rights. So there's always something operating upon the proceedings to make sure that things are moving along with alacrity. But to your more specific question, Misbehaving, no, they don't go bad. They don't go bad at all. I don't see why they would wait, but if they wanted to, they certainly could. Great question, though. There she is. Somewhere, Jay is got an itch on his ear now that we've talked about Wendi Adelson. All right, let's keep it moving here. Not my fault.
Hey Josh,
Glitch in the Matrix.
Crew, Mod, and Confidential Press Release. This is Court Lurker calling from Spokane, Washington. I had a question about sentencing-ish. So if, let's say the prosecution is talking with Katie McDaniel to get more information on Wendy's involvement in this whole scheme. Since Katie's already been sentenced, if she does give the state more information or help them more, can Katie's sentence get changed? Can they go back and say, well, you helped us, so you're going to be, parole eligible in 15 years instead of LWOP? I hope that makes sense. I appreciate everything you guys do. Hope you guys had a great birthday, Josh and T-Suze. And happy Sunday Fun Day, everyone.
Court Lurker, Spokane, Washington. Let's put you on the map. Always good to hear from you. Thank you so much for all your support and kind words along the way. Great question, too. So what Court Lurker is wondering, again, the Wendi Adelson questions always come in pairs, is what if that last little bit of information they need to secure an indictment against Wendi has to come from Katie McDaniel? And can they go back to Katie McBanois and offer her something to entice her to testify? She's already been sentenced to life without parole. Is that the end of it, or can they do something to, quote unquote, sweeten the deal with her? Well, the answer to can they is different from the answer to will they and should they. Can they? I think they can certainly try to. I think they could certainly go to the judge and file a motion for resentencing on Katie McBanois if they wanted to. They could go back and say, Your Honor, circumstances have changed, X, Y, and Z, blah, 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 based upon, whatever are the laws in Florida. We are asking for her to be resentenced and allow for parole after X amount of years. And I imagine it would be up to a judge to make that call, and it could happen. Ever heard of the Menendez brothers? They are, as they right now sit in prison, there they are. They're not sitting there looking at each other like that, but as they sit in their respective jail cells, they are parole eligible. These are two men who were at one point looking at the death penalty. They got sentenced to LWOP because the jurors couldn't agree on the death penalty. Or actually, I think the jurors agreed they should get LWOP. They were sentenced after conviction to life without parole, and they now have been resentenced and are parole eligible, and they may be getting out any day now. Don't be shocked if you see videotape of these two walking out of prison hand in hand. So it can happen. The better question, or not better question, but a different question is, will it and should it? I don't think the prosecution should do it. And I don't think that they will. And the reason for that is, think about the cross-examination of Katie McBanois, if that were to be true. Whenever somebody is given a deal, that always becomes part of the cross-examination. The only reason you're saying this is because you got this sweetheart deal. Imagine if you had already been convicted and sentenced to life, and now you're getting less than life in exchange for your testimony. It would just look like absolute purchase testimony. And the defense attorneys would have a field day with it, saying, wait a second, lady. You were going to be spending the rest of your life in prison, and now all of a sudden, Wendi Adelson had something to do with this, and you're getting out in 25 years? Oh, isn't that convenient? You're telling us you're telling the truth? Well, the truth sure sounds like it comes with a high price for you, Katie McBanois. I just think it's too dirty. And I think this prosecution, from everything they've demonstrated to us, are not willing to cut those types of corners. So I don't think it's going to happen. But could it happen? In the world of possibilities, it could. Thank you for that question, Court Lurker. All right. Let's keep it rolling here. We're doing well.
Hello, Josh and crew. This is Tracy Lynn Moland from Calgary, Alberta, Canada. First, congratulations, Josh, on the Dodgers winning. What a crazy series. My question today is specifically for you, Josh. I remember a few years ago hearing you talk about your most interesting case with Ana Garcia, and I believe it had to do with perfectly lined new security cameras and a fireman. And I would absolutely love it if you could please retell that story for us. Thank you.
Tracy from Calgary, Alberta, Canada. Our friends from up north, and I appreciate the Dodger love from a Canadian. That was a very hard-fought series on both sides, one for the absolute history books. 7 games. Game 7 goes into extra innings. Are you kidding me? Amazing. And I appreciate anytime anybody's going to remind me of that. So thank you so much, Tracy. Yes, I did Ana Garcia on her. She is a host on True Crime News. I also host a podcast on that channel. But Ana is the OG of True Crime News. And they did a series on that channel called My Favorite Case, I think it was called, something along those lines. We'll try to find the link for you guys. But she had me on, and I talked about, I don't know if it's my favorite case, but it's certainly a case that a lot of people like to hear about. I talked about when I was a prosecutor, I prosecuted this man right here. His name is Eulian, and he was a firefighter with the LA Fire Department. Here's the quick version of this story. He lived in this area where there was a problem with stray cats. That's just cracks me up. This is the way you have to start this story. There was a problem with stray cats. And a woman who didn't live in that neighborhood, but lived near that neighborhood, loved cats. And she would feed these stray cats. She would just bring little handfuls of kibble and leave it in the alleyway so that cats had something to eat. She's a very sweet lady. It mattered to her. It was like this small kind of kindness she could do in the world. She wasn't dumping bags full of there's the link if you guys want to watch it. She wasn't dumping bags full of cat food into the alley and creating this epidemic of cats. She was feeding them kibble, and one of the cats I think was injured and she wanted to check on the cat. She's just a very sweet cat lady. Anyhow, she rolls out there one time to feed the cats, and Ian sees her and confronts her and is like, hey, these are a problem. I don't want the cats around. Stop feeding them. Well, they start to get into it. And what should have been just kind of a back and forth, please stop. Okay, blah, blah, blah. It escalates into this horrible argument. And I'll try to tell this story with a little bit of intrigue to it. They get into a verbal argument, and that turns physical. And the next thing, I'm blanking on her name. The next thing she realizes is she wakes up she was in her vehicle, and she wakes up outside of her vehicle on the ground. And Ian is there along with Ian's mother, and she's going, Rebecca Stafford. Thank you for that, Caitlin. Rebecca says, what happened to me? And they say, you fell down. And she's like, I fell down. Oh my God. She has like a memory loss of what took place. They put her in her car and they drive her home. Next day, she's like, how did I fall down? That doesn't seem right. My head hurts. My jaw hurts. She goes to the police to report this. Somebody tells her, well, you should tell them what went on. Police roll out to the area where she say that she parked her car and this argument took place, and they see that there's a video camera, and they pull the footage. Lo and behold, that video camera had been installed like the day or two before. And when they get the video footage back from this, it is like a perfectly framed movie of this confrontation taking place in 4K high definition. And it shows Ian getting into it with her, and then he just loses it. And he was a big, muscular firefighter, and he pulls this woman who's, I can't remember her age, but she's a little bit older and not all that physical. He rips her out of the car, punches her a couple of times, and then gives her an uppercut that absolutely knocks her unconscious. And that's what happened. She ends up unconscious in the road. And when she comes to and doesn't know what happened, they tell her the story about how she fell down, put her in the car, and bring her home. So I prosecuted this case, and there's the prosecutor. There's the prosecutor that handled this real caper. And what ended up happening is on the first day of opening statements, look at that haircut, by the way. On the first day of opening statements, in walked the news cameras, and we didn't know anybody was following this. And Channel 7 walks in with their news cameras, and I go, what's happening here? And they go, oh, we're gonna tape this thing. And I'm like, isn't there more important things going on in the world? And they're like, not right now. Right now it's you, sir. So every single day of trial, gavel to gavel, there were video cameras in the courtroom watching this entire thing. So I would be driving home from court every day, watching little clips of what had taken place in court that day because they would cover it on the nightly news. Other little wrinkle on this thing is the first time we tried it, it hung, if you can believe that. I think it was like 10-2, and it just broke me. Their defense was mutual combat, that she started it, and it was self-defense, and it was ridiculous. And we had to try it again, and then he was convicted. So, you know, and I take no pleasure in convicting a firefighter, but when you see that video, when I first got the case, I thought, oh, we'll be able to work this out. He's a firefighter. And then I took a look at that video and I'm like, this is a felony. I'm sorry if he loses his job, but he nearly killed that woman. I mean, he punches her about as hard as you can punch someone. So thank you for that, Tracy. Crazy story. I don't know if it's my favorite case, but it's certainly the one that kind of haunted my career for a while. All right, let's keep it rolling here.
Good morning, Josh. Happy Sunday Fun Day. This is Carolyn calling from Highlands Ranch, Colorado. Well, technically, I'm at my other residence in Logan, Utah. So I know there's been some debate, but you could put Logan on the map because I do live here part-time. And I am here now calling about a case that's come back in the limelight here in Utah that happened back in March. I haven't heard much since then, but this is a case involving a mother named Jessica Lyman and her young 8-year-old son, Eli. Both were found shot in their home in Saratoga Springs. And apparently the FBI is now involved. They've been searching some bodies of water, looking for evidence. So this case is very prevalent again. And there are rumors that at the time her 15-year-old son was home during the killing. And there are rumors that he is involved. There's, I guess, evidence that's being found, but not much has been said. Probably because of his age. But this is just, it's of course another sad case, but very interesting. And I would be very interested to have you follow along and keep us updated on this as things go on. So wanted to bring this to your attention and hoping that you know, again, this is something that you might be able to look into and follow. Thank you so much, and I hope everybody has a great day.
Carolyn and yes, I'm going to make a judgment call on this because you domicile part-time in Logan, Utah. We're going to put Logan, Utah on the map. So there you are. Thank you so much for calling in. Great question. This is a question I think we had actually covered on one of our True Crime Minutes a while back, but a case that I think we will continue to keep an eye on, especially if there's a break in the case. Absolutely. But really tragic case from out of Saratoga Springs, Utah. Back in March of this year, Jessica Lyman and her 8-year-old son, Eli, are found shot in their home. And you're right. Initially, and I don't know where things stand on it now, but initially the 15-year-old son was a suspect. He had allegedly sent a lot of really kind of hateful text messages to his mother. There was like a handwritten note that talked about murder that they found. He also makes some suspicious statements when police arrive. He's there and he says that he was sleeping the whole time. And then he kind of spontaneously says that there's no guns in the house when no one had told him that they had died from gunshot wounds at that point. That's just kind of you say rumors. That was the evidence being reported back in March. But no break in the case, no arrests, no nothing. And now the FBI is involved, and they had been searching a nearby riverbank. So I don't know what that means. If they believe that maybe the weapon used has been tossed there, you know, good reason to do that search. But we'll continue to keep an eye on it. Really, really, I mean, it's a mystery at this point. But you know, you would have thought with that evidence that we heard initially that the 15-year-old son might be arrested on this, but it's been months now and that hasn't happened. So we'll see. But thank you so much, Carolyn from Logan, Utah, for asking that question and putting that case back on our radar. We'll continue to follow it. All right. Let's get through these things here, shall we?
Hi, Josh and the CC crew. It's Bess Nancy from Newport Beach, California, just down the road. I have a question about Brian Walshe, and you'll probably answer this before Sunday Funday, but it's on my mind right now. Do you think he pled guilty to witness intimidation and the charge of disinterment so that they could not use that evidence in the murder trial? It just seems to me, why not just plead guilty to the whole thing? But if that information cannot be used in the murder trial, maybe it weakens the state's case. Anyway, just wondered what your thoughts are about it, and hope you all have a great day.
Best Nancy, Newport Beach, California. Thank you so much for the excellent question. This is something that a lot of people had been asking. We have talked about it on the channel here before, but it probably is good to repeat. Talking about why did Brian Walshe take these guilty pleas at the 11th hour before heading into trial? And why, if he's pleading guilty to stuff, why not plead guilty to the murder? And why plead guilty to anything if you're not going to plead guilty to murder? Does it give them some sort of advantage? I really do not think, unless I am missing something entirely, that this is some sort of 3D chess that we're all trying to figure out how they've bamboozled everyone. The question, and we kind of talked about this earlier, the question of whether or not they could bring in the evidence of the crimes that he pled guilty to it's still the same threshold question of relevance. If it has relevance to the murder, then they're going to absolutely be able to prove it. And he can't just somehow dissect this case and cut it apart and put a wall in between certain evidence because he happened to plead guilty to that underlying conduct. It's the conduct that is relevant. The convictions are another story. Will the jurors hear that he's actually suffered felony convictions? I'm not sure. They might just hear that he's actually admitted to that conduct. The prosecutor will certainly say that you've admitted that you did X, Y, and Z. Isn't that true, sir? But whether or not they will talk about, didn't you in fact plead guilty to this, I think will have to be decided by the judge. Or the defense may say, we want that in. We want to be able to say, yeah, he pleads guilty to things he did, but not things he didn't do. I don't think, though, I think the minimal advantage here to the defense is they took a look at those Google searches and they said, listen, you're searching for things like how to dispose of a body, how long before a body starts to smell, how do you dismember a body? I mean, we can't get around this. There's no argument we can make to get around this. So if you admit to that, we clear that from the table. We show that you've admitted to what you did do. And then we just explain why you did it, but you don't admit to the murder. So now they're in a position where I think he's going to have to testify, and he's going to have some really banger of a story to say, for whatever reason, innocent of me. She took her own life. She fell down the stairs. Somebody else killed her. I guess another possibility is we got into an argument and she died, but it wasn't murder. It was a involuntary manslaughter at best. Maybe that's even the best argument he can make, but it wasn't murder. And then after that happened, I panicked and I got rid of her body. That's some variation of that is going to take place during trial. But the prosecution is going to get into the dismembering and the disposing of the body and the lying to police. And all of that is still fair game because that goes to their theory of motive, prior bad acts, which we talked about before. It's relevant because it goes to his motive. He killed her, and only a person who killed somebody would have a reason to hide their body and lie to police about it. That's the relevance for it. So it'll all come in. Just really strange set of circumstances. I've not seen this before. I've seen people take 11th hour pleas, but not to like part of it, not the other parts of it. Thank you so much, Best Nancy from Newport Beach. Let's keep it rolling here. Where am I? Here we go.
Hi Josh, this is Hayley from Cornwall, England. I just wanted to get in touch and ask you about a cold case really. It was in Florida in 2006 and it was Jessica Kesse. Recently, the police have said that it's no longer a cold case, but strangely they haven't named who the suspect is for the murder, and I just wondered why they would do that really. I know, for example, because I was thinking maybe it was that the suspect had passed away. But, there's a lot of recent ones really. But one, for example, 63 years ago, the murder of Caroline Doherty in Bristol. She was murdered, and they've just found out that it was someone that has passed away. But they still named the person. So, yeah, it's a bit baffling. Just wondered what your thoughts were, really. Thank you.
Haley from Cornwall, England. Thank you so much for calling in. Thank you for putting Cornwall on the map. Is this our first Cornwall caller from, I don't know. Kaylin's giving me a, just move on, Ritter. Anyhow, thank you so much, Haley. Great question about the Jennifer Kesse case. She went missing in January of 2006 out of Orlando, Florida. I am fully willing to admit when I am not aware of a case, not aware of the circumstances about it, not in the weeds on it. And so I don't want to fake it and do a bunch of research and act like I know everything about it. So what do I do in those situations? Do you have me stumped, Haley? No, you do not, Haley. I'm sorry to say, because I can always phone a friend.
Hey guys, okay, great question. How is a case no longer considered cold and yet they haven't named a suspect? This is actually quite common. It just means the case is actively being worked, and that could be due to a few different circumstances, but let's talk about Jennifer Kesse specifically. And in her case, it's for a few different reasons. First off, the advancements in science and technology. They're using existing evidence to re-examine it with the advancements that we now have specifically pertaining to DNA testing. Secondly, they're taking a secondary look at all the information, all the evidence with a new, fresh perspective through the Florida Department of Law Enforcement. And finally, they've narrowed down the person of interest pool. How they did that, they haven't said yet. My guess would be due to these advancements in science and technology, taking existing evidence and re-looking at it through this new perspective of what we can do with it today. Hope that answers your question.
There he is, the man, the myth, the legend, Derek Levasseur. He's such a great guy, and he's so awesome for agreeing to help us out here on this. And he's been doing some deep dives. We're going to include all of his social media and YouTube links. And he actually did recently an episode on the Jennifer Kesse case. So he's in the weeds. He knows what's going on with this one. And like he said, it sounds like there have been developments. It sounds like those developments may be tied to advancements in DNA technology, which we're starting to see more often. And we will continue to see as this science continues to get better and they're able to use smaller and smaller pieces and more degraded pieces of DNA information. They're able to start to get breaks in these cases. But law enforcement's telling us that, but not much more. And so they're being a little tight-lipped about a cold case that might be warming up, as it were. But big shout out to Derek. Please send him some love. If you guys are fans, you should go subscribe. If you do, hit up his Instagram or his Twitter account and send some love from Courtroom Confidential. Send him some juice boxes. Tell him thank you so much for helping us out. And thank you for flexing his Christmas tree. in the background, by the way. Did you guys see that? It gave me Christmas tree, I don't know, anxiety. Like ours is looking like the little kind of sad Charlie Brown Christmas tree in comparison to that 12-foot wonder fully lit up and ready to go that he's already got in his house. So again, Derek's the best, and we appreciate everything he does for us on the channel, and you should send some love his way. All right, let's keep it rolling here. First of all, Jude the Tiger, thank you so much for sending the coffee mods and keeping those mods wide awake. And please hit the like and subscribe buttons. That's right. If I haven't said it enough, I'm going to say it again. Take a moment, take a deep breath. We're actually almost to the end. We got our last couple of calls here. Sad tears. While you're having your sad tears, take a moment, hit the like button if you haven't already. Subscribe if you haven't already. You will not regret it. And it's free. It's free to subscribe. So thank you guys for all your support. All right. Last couple of questions here. And this next one is special for a reason I'm about to tell you. Here we go.
Hi, Courtroom Confidential. This is Sonia from Chicago. Hi, I hope everybody's having a great day. Happy Sunday Fun Day. And my question is about Brian Walshe. So I do believe that the pleading guilty to the charges that he did was a Hail Mary defense strategy. And I do believe that they have a chance depending on what kind of jury they get. And so, I mean, we got Kesse Anthony, right? I mean, I just keep thinking back of her. So what do you think, Josh? Do you think this is going to be won or lost? Well, obviously it's the jury's decision, but how important do you think jury selection is going to be in this case? And do you think they have that Hail Mary shot? Because they don't have the physical evidence that he pew-pewed her. Just the evidence that he did other things that he pled guilty to. So I don't know what you think. Looking forward to hearing back. Glad you're feeling better, Josh, and thanks so much for doing this.
Sonia from Chicago, Illinois. Thank you so much, Sonia, for calling in, always asking wonderful questions, for being one of our mods and one of our biggest supporters here. And Sonia has the distinct honor of being our 1,000th message. Can you believe that? 1,000 messages you guys have left over the time that we've been doing this. That is incredible to me. When we first had this idea about doing Sunday Fun Day and having people call in, we were even concerned that we would get no questions. And I think we even talked about, well, you know, if it's 2 or 3 a week, I'll just answer those and we'll fill the time with other stuff. And now it's every single week we have more questions than we have time to answer, and we're already up to 1,000. Can you believe that? Thank you so much, Sonia, for bringing us over that hurdle, over that milestone. And a great question, too, about Brian Walshe. How important is jury selection going to be in this case? Well, jury selection is going to be incredibly important in this case, as it is in every case. I think jury selection is probably one of the most important things in every case. In fact, it probably is the most important thing in every case. I mean, you still have to have evidence and you still have to prove it and you still have to put on a trial. But even with the best trial and evidence, and you guys have seen it, if you don't pick a good jury, it could all fall apart. And you could end up with, you know, a hung jury or worse in situations where you might have a very strong case. And for the defense, if the defense doesn't do things right, they may end up with a situation where they're just getting kind of railroaded because they missed out that these jurors are just going to convict whoever happens to sit in the defendant's seat. I think, though, for the defense, because they have this kind of wild, hard to believe story, they are going to have to find jurors who, well, the better way to think about it, and I always say this about jury selection, is who don't they want? Because it's less about picking and more about kicking. Who do they want not on their jury? Who they don't want are common sense people. What they don't want is that guy that just kind of sits there with his fingers crossed on his chest and just kind of tunes out because he's a common sense guy. The common sense people are going to see right through the outrageous BS of saying, my wife died and my first instinct was not to call 911. My first instinct was to chop up and dispose of her body. The more I think about this, the more I think that it's going to have to be something along the lines of, we got into a fight and this accidentally happened. And I thought nobody would believe that. So therefore I hit her body because you guys were already trying to convict me for a bunch of paint frauds, for a bunch of art fraud, that I thought there's no way that you would understand that she fell down the stairs. And so when she fell down the stairs, I thought I got to get rid of her body. That's what it's going to have to be, something like that. That's the only thing I can buy. But even then, that's ridiculous. So you don't want common sense people on your jury. But yes, jury selection is going to be very important. Sonia, you're fantastic. Thank you for the question. Thank you for being our 1000th message. All right, everybody. It's that time. It's our last message of the day. What a wonderful day, though. Did you have a good time? We talked a lot about Brian Walshe and some cases we hadn't heard of for in a while. Jessica Lyman. We had a song. You had musical entertainment. How much happier could you be? Jody Arrington played us a beautiful song. We're gonna print that out on CDs and create an album. And Derek even made a surprise appearance. So great day, I think, so far. All right, last question. Here we go.
Hi, Josh. It's Granny Detective from Calgary. I found it necessary to take a mental health break from all this crime. And I just want to thank you and all the others for doing this very hard work. I don't know how you do it. I would like to know why basically on the eve of trial, lawyers are still discussing what evidence will be allowed in both Walshe and Richins cases, especially information about the financial implications and whether it's too prejudicial. This appears to me to be a major contributing factor in both of these cases and has such huge implications on how both sides present their case. So why is this not determined months in advance of trial? Murdaugh was a case where financial benefits were the primary reason for this terrible crime. It's such a key element, and I find this so frustrating that they're still discussing it. And then in the David case, this girl was only 13 or 14. What could any of the other people, the other adults around her, be held culpable? Because at 13 or 14, she should have been in school. Why weren't they asking these questions? I think they should be held accountable. Do you? Thanks very much, Josh.
Granny Detective from Calgary, Alberta, Canada. Thank you so much for bringing us these questions about cases we've been following so closely these last couple of weeks. Yes. Yeah, I guess I take for granted some things. And Granny Detective's question is, Brian Walshe, Kouri Richins, especially in Brian Walshe, these things are about to head to trial. Why are we still talking about what evidence is going to come in or not? That is not all that uncommon. Lots of times you're having your evidentiary hearings right before trial. I think that's also why you have a lot of pleas that take place right before trial, because people are kind of waiting to see what's going to come in. Before trial, you're doing a lot of discovery. You're doing a lot of making sure everybody has enough evidence. Perhaps you are litigating some things, but for some reason, lots of courts like to handle the evidentiary stuff right at the very end. In fact, here in Los Angeles, I'll let you know how it's done. In a lot of these kind of garden variety felonies where they're not especially assigned to a judge, when you're ready to go to trial, they send you down to the master calendar court. So let's say you're going to begin trial on Monday. On Monday, You on the week before, you're in your home court, and that judge sends you to the master calendar court on Monday, a totally different judge. All that judge does is send your trial out. So you get in there and you go, are you ready or are you not ready? Yes, we're ready. Okay, great. All parties report to Department 102. 102 may or may not be the court you came from. If the court you came from is open, they'll probably send it back to that court because they're used to the case. But many times you get sent to a brand new judge you've never been in front of. Then you get to that judge, and then you have what are called your 402 hearings. And that judge will decide what evidence is coming in or not, what things still need to be litigated. So you might be having a jury come in an hour that you're going to start picking, and you're still trying to figure out, is this statement coming in? Is that statement coming in? Is that witness going to be allowed to testify? So yeah, this stuff can be handled very close to when trial takes place. The David case. First to your question, and then some updates on this case if you guys have not heard. To your question about who else should be looked at. Should the parents be looked at? I don't know. From a criminal perspective, I don't think so. It sounds like they were having a lot of trouble with her. Sounds like she had been running away quite a bit. Were they less than ideally involved in her life? I don't know. And they've been through so much, I don't want to kind of point fingers at them. But certainly other people in David's crew who may have been aware of her age or the fact that she was running away from home, there might be criminal liability there. And it does sound like we are getting very close to arrests being made in this case. First, inside sources, LAPD saying nothing, but inside sources close to the investigation are telling outlets that David is a suspect and this is a homicide investigation, and that he is no longer cooperating with that investigation. The other thing we're being told is that it is likely that a second person is a suspect linked to her death, not just the cover-up, but to her death. There's also this information we're hearing about that his phone, it's either David's or this other person's phone. And again, none of this is coming from official sources. May have been in the Santa Barbara area for a curious amount of time, close to the time that they believe that she died. That is causing a lot of people to kind of run around with suspicions. And then the latest, and this is being reported by TMZ. And I just want to say they're reporting it and I'm reporting what they're reporting. What their sources are or how they've been vetted, I don't know. But that when her body was found, that she had been, and this is graphic, she had been decapitated and dismembered, and that her body was partially frozen, which to me is kind of the most difficult to wrap my hand around of all of it, because her body was inside of the trunk of a car that had been, one, abandoned for some period of time, and then at a tow yard for some period of time before they started to notice an odor that caused them to open up the car. How that body could still be in a state of partially being frozen is beyond me. But if this information is correct, it looks like at one part, maybe her body was put somewhere in a freezer and rock solid by the time it was put inside of that vehicle. But just horrible way in which her body was treated, if all of this is true, which does lead you to believe that, people who could be responsible for that could also easily be responsible for her death. But again, no official charges, no official statement from LAPD, but it does look like things are really starting to heat up on this case. Thank you so much, Granny Detective, for that question and for closing us out for today. Thank you for all of you for your questions. And if I missed your question, please don't be discouraged. Please send us another question and we'll get around to answering that next week. But you guys are all fantastic. Here's some quick announcements and then I'm going to get you out of here. First of all, go to thecourtroomconfidential.com. That is our website. We put a lot of work into it. And here's what you will find. First of all, if you would like to participate in Sunday Funday, you've heard all these cool questions and you say, well, I've got a good one that you didn't answer, Ritter. you can leave us a message at thecourtroomconfidential.com by clicking on the leave a message button. And it's easy to do, and plenty of people have figured it out, and so should you. Also, if you've seen people receive memberships today, you've seen people who are members for several months, we appreciate all of your support and for being a part of the CC crew. And if you want to become a member, learn about all the perks of membership, and there are lots of perks. Tell them, members, tell them that there's lots of perks. You can become a member by clicking on the Become a Member button at thecourtroomconfidential.com. And finally, the holidays are coming up. The Ritters may not have their Christmas tree up just yet, but we do have merch available for you. The merch includes all of the new colors that you see, including this shirt. What is it? What are the guesses on this one? I do like this color, by the way. This is part of our new fall palette. Ritter Rainstorm. Bingo. The therapist, you know, has been waiting on that one all day. Nefarious Navy. I like that as well. It is kind of a very cool... I mean, I would easily wear this about. Indigo Injunction. Ooh, deep dive on that one. Like that. Deep cut, as we say, from Afton. No, Notorious Navy. I think it's probably, what is it? Dark Blue is probably the name of it. Tell us. Blueberry Chill, says Bice. Midnight Plea Deal, says Farm Girl. All right, what is it? What is it, Tiff? Whatever it is, it's available on our shop right now. Please go check it out. One more thing. I'm kind of skipping ahead in our announcements, but it seems appropriate. Oh, Midnight. That's actually not horrible a name. Speaking about our merch, what is happening Thursday? Thursday's Turkey Day. And then what happens Friday? Friday is Black Friday. And what happens on Black Friday? On Black Friday, we kick off the holiday purchasing season. Well, we want to join in the fun. So this Friday, we are starting our Black Friday sale. And that will include 20% off for everybody on all of our drinkware. What is our drinkware? I had to learn that term myself. That is our tumblers, like this Pinot on the Go Courtroom Confidential crew that says, let's get juice. Our larger tumbler. These are really nice quality stuff, by the way. Also CC crew and let's get juiced. Some other, well, this mug. We've got the black one, but then this brand new one that says what's happening here. Plenty of other stuff. Check it out. It's all on the website. And it's all going to be 20% off starting this Friday. I think we're going to, what are we doing? A code? Is that how it's going to work? Or is it just marked off? They're going, don't ask us question, Ritter. Just keep on reading your script. All right. What did you miss? It's marked off. So it's all marked off. Have fun. Good stocking stuffers. Give it to your loved ones. Everybody enjoys a hot beverage or cold beverage now and then. We got you covered. What did you miss this Friday? We had our weekly roundup. It's already up on the channel. Please check it out. We talked about the Anna Kepner case, the Brian Walshe case, the Melody Buzzard case. We didn't get one question on that one today, but there's been some disturbing developments in that one. So please check it out. Kouri Richins, we also talked about her. That's all up on the channel right now. Stay tuned this Monday. So because it's the holidays, we're going to kind of give everybody a break, but that doesn't mean that we don't have fun stuff for you to watch. So Brian Walshe, that trial is about to start. In anticipation of that, we went back to our case notes episode that we did on this case, and we redid it for you. We I don't know, what did we do? We updated it for you. And so we're doing an encore presentation of our case notes on Brian Walshe. It is a deep dive. It gives you everything that you need to know. All the details up to date to today on the Brian Walshe case. So please check that out. We're going to premiere that live at 5 p.m. Pacific, 8 p.m. Eastern on Monday instead of our Monday docket show. Revamped audio and added major updates. What do they call that when they do that for a record where they, what do they call that? I don't know. I'm blanking on the term, but you know that they re-engineer it or something, whatever it is. Remastered. Yes, it is our remastered case notes. Please check it out. Very proud of the work that we put into that, all the research. Wednesday, no Wednesday night live. Boo-hoo. It is the Wednesday before Thanksgiving. You should all be hanging out with family and friends and having a couple of cocktails. But that does not mean you will go without entertainment, because I am very proud. If you haven't heard this announcement already, I'm very proud to announce to you now that I have been asked to co-host a brand new weekly true crime show on Fox Nation. Fox Nation is a streaming application and service. Please check it out. Please subscribe if you haven't. I think they do have introductory offers that you can check it out. And at least for anything else, please check out this brand new show called The Weekly Rap Sheet. We're premiering our first episode this Wednesday at noon Pacific, 3 p.m. Eastern on Fox Nation. It's hosted by myself, along with Paul Morrow, Donna Rotuno, and we had a blast doing it, and I hope that you guys enjoy it. So that's coming out on Wednesday. And then on Friday, no weekly roundup. Take the day off, enjoy it with friends and family, recover from all the turkey that you overindulged in, but get right on the courtroomconfidential.com and get your 20% off all drinkware starting on Friday. And then, yes, we will have Sunday Funday. We will be back here next week, Sunday Funday. Leave us those messages. We'll answer them 9 a.m. Pacific, noon Eastern. And to get into the following week, because we're not going to see you again till Sunday, Brian Walsh's trial does start on Monday, December 1st, with opening statements, and we are going to be covering every minute of it, streaming it live on our sister channel, Courtroom Confidential Live Trials. Please check it out. Please subscribe if you haven't already. You don't want to miss a minute of it. We're going all in on Brian Walsh, so check that out. Did you like already? Did you guys hit the like button? Did you subscribe already? Please don't forget to do that. Thank you so much to Afton, Sonia, Kathy, and therapists, our mods, for being keeping us all happy, keeping us all in line. As you heard, best mods on the tube. Kaylin, you're fantastic. Thank you for putting up with me. And Tiffany, you are, as always, the best thing that ever happened to me. Take care, everybody. Have a wonderful Sunday, and we will see you. You heard all the announcements, but I'll be seeing you live again next week. Take care, everybody. Bye-bye.